Good morning, ladies and gentlemen. My name is Duncan McNair. I'm a barrister with 3PB. With me on the line is Andrew Sands. He's an independent financial advisor from the Nestor Financial Group. We're here to give a seminar on settlement negotiations and periodical payments. Just a few words about the format of the session today. We'll each be doing 25 minutes on our topic. There will be slides. You will get the slides afterwards, so don't feel the need to write everything down on them. After those 50 minutes, we will have a 10-minute Q&A session. We will work that through the Q&A button that you should see at the bottom of your screen. If you think of a question, hit the Q&A button, type the question in, and we'll try and answer it towards the end. We have quite a large number of attendees, so depending on how many questions we get, we may or may not get through them all in 10 minutes, but we'll try our best. One point to bear in mind is that this is not a private group, so anyone can see your questions and anyone can hear our answers. If you have a very case-specific question, you may want to save it and try and get in touch with us afterwards, perhaps through our clerks. So, unless anyone has any questions or comments, I propose to dive straight in with the start of my talk. Let me just try and get the slides running. Okay, we should now have the slides. Good. I am here to talk about settlement negotiations. This is a very important topic. It's a very important topic because in almost every multi-track case, the final outcome is one way or another, some kind of a settlement. Whether it's good settlement or a bad settlement for one side or another is all about the job we do. But the number of multi-track cases that finish at trial are really very small indeed. The focus in our professional training on settlement negotiations is, in my view, not good enough. It's quite hard to find decent training materials. The training we had at bar school was certainly not reflective of true practice, and it's quite difficult to find out where to go from this. So what follows is my own account of my own experiences dealing with negotiating settlement. It is focused on the claimant's perspective because the bulk of the work I do is for the claimant. I understand most of you are claimant practitioners anyway. Those who are not, well, consider this an interesting chance to see the dark side. You can hopefully learn something by seeing how the poachers do it, if I could put it like that, when you come back to your own gamekeeper's practice. So, how do you negotiate settlement? It's essentially a three-step process. Determine your own minimum settlement value, elicit the defendant's best offer, and if the defendant's best offer exceeds your minimum settlement value, accept it. Otherwise, proceed. It sounds like a wonderfully simple process. In fact, it's immensely complicated and depends on a number of very interesting and difficult factors. The first interesting question, I'm sorry, my slides have gone a bit wrong, excuse me. There we go. The first interesting question is, how do you assess the value of the case? The actual process of assessment is far beyond the scope of this talk. We have spent many years learning to value a personal injury claim, and there are hugely complex issues you have to deal with. I can't go through those in 25 minutes, but what I can discuss is the process of assessing your valuation. So not the nitty-gritty of experts and liability disputes and causation disputes and quantum and so on, but the way you think about these things. And the way you think about these things has to be based on probability. I hope many of you have seen this curve before, and whether you studied it enough to know it as the normal distribution or whether you've heard of its alternative names, one way or another, you end up looking at a bell curve of probabilities. And on the x-axis, on the horizontal axis, you have a financial outcome in pounds. The vertical axis is the chance of it happening. So the higher the peak on the curve, the more likely it is to come to pass. The lower the level, the less likely it is to come to pass. The further left, the less money, the further right, the more money. And this is a very simple bell curve setting out a midpoint, a most likely valuation somewhere in the middle, a most likely outcome there, with a long tail of outcomes stretching to the left and right. So you're quite likely to get a final outcome from a trial judge somewhere in the middle, and you're less likely to get a result passing down the shoulders and along the arms on either side. That bell curve is intrinsic to everything we do. That is essential to the valuation because you're not valuing a certainty. You can't say we are definitely going to get this or we're definitely going to get that. You can only say we're probably going to get this, we're probably going to get that. The defendant has the following chance of establishing its medical excellence. It can get more complicated even than that, because this is a simple single bell curve. It reflects perhaps a straightforward factual dispute on quantum, where there's a long tail in either direction and a midpoint which is most likely to come to pass. You can also get twin bell curves. That's particularly apparent if there's a liability dispute. Because if there's a true liability dispute and the defendant's right, then there's going to be, at one end, simply zero. If you go to trial and lose on liability, you are getting nothing. If you go to trial and win, you may very well get some huge amount that's very far down the line. You can also see such twin bell curves if there are disputes between the expert evidence. For example, in a chronic pain case where on your experts, there's a pain disorder caused by the accident that has led to some huge losses, or on the defendant's account where there's been say a 6-month orthopedic injury and no pain disorder has resulted, where the defendant's experts say the claimant would have been in the same place regardless. So you can get twin bell curves, but you have to keep your bell curve in mind throughout the entire process. What stage of proceedings are you at? Well, the earlier it is, in a way, the harder it is to settle, because there are more unknowns. From a claimant's perspective, you have an advantage, because you get to put your case together before you issue proceedings. Indeed, you'll often be getting everything together, getting your own case ready before the defendant even really knows what's going on. Having said that, it's easier to settle when the evidence is complete, because there you know where the battleground lies. The best case scenario from your perspective is that the defendant doesn't dispute liability, although hopefully you'd be aware of that before you issue. The defendant's experts largely agree with your experts, and the only questions really are where exactly the shoulders and the arms of the bell curve lie. That's a best case scenario. A worst case scenario, well, inevitably from the claimant's perspective, the worst case scenario is where you get the surveillance DVD landing on your desk a few months before trial. And we all have horror stories of what that can show. In a worst case scenario, really, it can lead to the complete collapse of the claimant's case. But even then, you've got questions of what the experts say, whether your experts or their experts fall apart in the joint statement process, and where it ends up. Settling early can be good for you because you know more than the defendant. It can be bad because you might be gambling on what the evidence is going to turn out to show. That can be particularly difficult where the defendant makes an early offer. I've been talking about your valuation, and of course, from a lawyer's perspective, that's exactly what you're doing. You're putting your value on the risks and benefits in the case. But you have to ask, whose valuation is it? I am sure all or most of you will have heard of the Montgomery decision. Certainly anyone who practices in clinical negligence will have done. It is a complete transformation in the approach the courts take to informed consent in clinical negligence cases. Before Montgomery, the law used to say that a doctor could rely on a responsible body of practitioners, the Bolam test, to say, well, a responsible body wouldn't have warned you about this risk, and I didn't, and therefore I'm not negligent. Montgomery changed all of that. It put the power back in the hands of patients and said that it's for the doctor to advise the patient about any material risk. And it's a question of fact what risk is material. I won't go through the details because it's beyond the scope of this talk. But where it relates to this talk, relates to your own advice to the client about the risks and benefits. It's very easy to think, well, we have 60% prospects of beating the offer. Of course you should reject it. That's simply the advice I'll give. My view, following Montgomery, is that we need to start getting claimants more involved in that aspect of the decision-making process. It's not just about saying, we're probably going to beat that offer, we're probably going to get a better settlement if we push on. That's what you must do, that's what you should do. You have to explain to the client exactly what the risks are, what they stand to gain if they accept the offer, and what they stand to gain if they reject it. That is particularly true in the post-2013 environment. QWOCs, qualified one-way costs shifting, is now a potentially huge factor in a claimant's decision-making process. First, let's imagine that there is legal expenses insurance backing up the claimant, and if you're acting on a conditional fee agreement. That usually means the case has to have 51% prospects of success. So if a defendant's Part 36 offer lands on the table, and there are 51% prospects of beating it, usually the legal expenses insurer will be content to proceed. Usually, but not always. I've seen higher thresholds, 55% occasionally pops up, even 60%. So if you're in that situation, the claimant needs to understand it. The claimant needs to know that the decision-making process must include the insurer. And if you say to the insurer, we have less than 51% prospects of beating the offer, usually the insurer will then pull the plug on the case. That doesn't mean the case is over. It means the claimant can continue, but would continue without the benefit of the insurance. Having said that, if there's an LEI, there's nearly always a CFA as well. And if you're on a CFA and you think there are less than 51% prospects of beating the offer, you may very well be triggering whatever clauses in the CFA will allow you to terminate it. And again, that's advice you have to give to the claimant. It's ultimately the claimant's decision. It may look like the decision is a very bad one if it means continuing to litigate as a litigant in person or trying to find the money to pay for litigation themselves, facing the costs risk themselves, but it's still a decision that's ultimately down to them. I don't think I've ever had a claimant actually go down that road, although every now and again I've had a claimant who's decided to seek alternative advice elsewhere. It doesn't happen very often. They're usually prepared to take it. If there isn't legal expenses insurance, then QOX is an even more important point, because that QOX means that subject to a liability dispute, any adverse costs order will come out of the claimant's damages. So if you say we have 55% prospects of beating the offer, we should continue in the face of it, that's all very well, but instead of being an insurer who bears the adverse risk, and of course it's their job to assess risk and take the losses along with the wins, if it's the claimant's own risk, then it puts them in a very different place. My own experience tends to be that claimants are reluctant to bear very much costs risk themselves. If there's an offer which you're even quite likely to beat, they get very jittery about the thought of tens of thousands of pounds in adverse costs coming out of it if you gamble and lose. And again, you must explain the risks and benefits to them. You must make sure they understand that and they make their own informed decision. We can advise them, we can guide them, we can act on their instructions. We can't make these decisions for them. All we can do is tell them what the risks are and what the benefits are. How do you explain this to the client? Well, I usually try to invest in the help of Mr. Noel Edmonds. Deal or No Deal was an immensely useful TV show in that regard. My experience more recently has been that claimants are less likely to have seen it as it fades into the mists of time, but nevertheless, it's a hugely relevant thing in explaining this stuff to them. You probably have seen it yourselves. If not, find an episode online somewhere and just watch it, because it's really useful. You have a claimant, if I can call them that, who gets an option to pick a box from dozens of boxes. I think it's 50 or 60 boxes. And in the box is a sum of money. And it could be anything from 50p right the way through to, I think, 100,000 or 200,000 pounds. The options covered a hugely wide range of outcomes. And they would have to pick a box knowing absolutely nothing of what was in it, save that they would understand the range of outcomes they might have. So they would pick a box. They would then have Noel Edmonds open other boxes, so open boxes they didn't pick to rule them out. So if they open a few low-value boxes with 50p, a pound, £2 in it, they can be more confident that their box is worth more money. So they're more likely to get a higher valuation on it. Conversely, if they open other boxes and they have high value amounts in them, they're thinking, well, my own box probably isn't one of those, therefore its true value is lower. And throughout this process, Noel receives offers by the black telephone you see him holding there from the banker. And the banker will offer effectively a settlement value to the claimant. The claimant can choose either to accept the settlement or move on. And the process ends ultimately with the claimant opening his or her own box and finding out what he or she has got, if he or she has rejected the banker's offer. That is a very good, very strong parallel to the settlement process. Because at the very outset, you will effectively pick a box. You don't know what the outcome will be at trial, but you'll find out if you run the case that far. Then as the case progresses, you gradually open more and more boxes and get more and more of an idea of what the outcome is likely to be at trial. Then finally, the outcome becomes perhaps obvious if you get through to trial. If you're just before the start of trial, you might have two possible likely outcomes that might be a long way apart. That is a good way of explaining to the client how the risk runs, because many of them have experience of this. How do claimants approach valuation? These are the three categories I tend to see. Sometimes you get people who switch from one to the other. Sometimes you get people who have aspects of both. but usually you get either timid clients, bullish clients, or planners. Timid clients can be difficult to advise if there's an offer that's not quite high enough. Remember that ultimately the client's decision is the final one, and if they would prefer to settle early rather than fight through to get a higher settlement, that's ultimately a matter for them. As long as you've given them true advice on the risks and benefits, they can choose to make that decision. The bullish are nearly always difficult. Try and explain the risks from an impartial perspective. In particular, try and focus them on the final outcome, what it's going to feel like going into trial, knowing that there is a risk, knowing that you could lose. They tend to get less bullish as the case progresses. Most people do. Litigation is a stressful process, and it usually grinds people down to a significant extent. The planner. These usually tend to be rational. They usually have a settlement figure that they want to get, and will be happy to take any offer that exceeds that, but will be very unhappy to take an offer that doesn't. Again, you can explain to them the risks and benefits. That may involve explaining that if they work a bit harder, push a bit more on the defendant, they may get more than they had wanted. It may involve the opposite. You may have to explain that they probably won't get the amount of money they want for the plans they have. How do you elicit the defendant's best offer? This is really the key. The most important thing is to get a true valuation and be confident in it. You need to know where the bell curve lies, where the peak is, or where the peaks, plural, are. Pressure of time usually improves offers from the defendant, assuming everything else stays the same. And you must be willing to walk away, or you must be willing to give the very strong impression to the defendant that you're willing to walk away, even if you're not. Evidence can develop with the passage of time. If you press forward and the evidence changes against you, the settlement value may drop. That's a particular hazard if you've rejected a comparatively early offer that still bites in costs terms, and settlement value drops. You may wind up looking back at that and thinking, well, okay, we're not now in a happy place regarding that offer. So beware of that. How do defendants tend to approach this? Well, the most common approach in my experience is a progressive approach. They start low and tend to build on it. You see it at a JSM where parties tend to start further apart and then hopefully progress towards the middle. At a JSM, you'll usually see 3, maybe even 4 offers, each a smaller distance above the previous. Picking your own offer is a real art form. You have to be high enough to leave room to reduce it, but low enough to show you're serious about settling. Defendants are often very good at getting just below the peak of the bell curve, where it looks quite attractive to a stressed out claimant, but isn't quite the midpoint. They may threaten a slightly lower Part 36 offer if you walk away. The answer, as always, is to be confident in your valuation. You know what advice to give, and leave the claimant to make his or her own decision. The bluff. This is one of my favorites. I see it time and time and time again, and I keep seeing it in cases that I really didn't think were bluffs. I even had a case not too long ago where the defendant maintained a bluff for about 1.5 years, leading up to a liability-only trial in a high-value cervical spine road traffic case. And they even pulled a mediation. They refused to go to a mediation on the basis that they wouldn't even countenance a split liability settlement. They would only countenance, in effect, a nuisance value financial settlement. It was a tiny fraction of what the true claim was worth. 1.5 years later, a week before the liability trial, we wound up negotiating a highly satisfactory liability split. The answer to the bluff is to be confident in your valuation. Has the case gone horribly wrong? If so, it ought to be obvious. You should look at the case and think, well, okay, this has gone horribly wrong. This probably isn't a bluff. But if the case hasn't gone horribly wrong, the defendant may well be bluffing. And I've even seen JSMs 4, 5, 6 weeks before trial where the defendant comes in immensely bullish, often offensively bullish, and they've wound up having to make a sensible Part 36 offer because that's what the case justifies. Contrast this with the robust non-bluff. It's very important to distinguish this from the bluff. It's more common when there are 2 peaks in the probability curve. It may be the defendant is simply intending to fight through on to a trial on liability or a trial on causation. It's more likely in higher value cases where the amount of costs at stake at trial may be small compared to the amount of damages. What are the actual chances of the defendant winning? If this really isn't a bluff, if this really is a difficult liability case where the defendant will either win or lose, where you'll either win or lose. It's a high-risk strategy for both sides. You have to choose, the claimant has to choose between a low offer and a gamble at trial. Mediation or similar can be helpful to draw out the defendant's true position, but then the true position might just be, we're not bluffing, we really intend to go to trial. That can be a difficult choice. On the plus side, an actual trial will at least lead to a true result, if I can put it like that. Settlement at a very low level may frustrate a claimant if they've got a low value from a case that could have been worth very much more. At least going to trial, they'll know that they've had the outcome from the judge. The victim. This actually is my favorite approach from the defendant, where something's gone badly wrong. The last case I saw where a defendant behaved truly like a victim is where they'd made an unwise additional claim. They brought in a whole string of contractors and subcontractors and so on, and there was a huge chain of consequential costs orders just waiting to be made, entirely unrelated to the claimant, because we hadn't sued any of them. And the defendant realized that they just had to get out of it. They just had to settle for whatever terms they could get. We managed to take full advantage. Make sure you recognize that. Start high and stay high. Other possible approaches that could lead to a victim defendant might be extraneous publicity or similar, particularly if the defendant is in a vulnerable place in that regard. The early offer. This is one of the most difficult situations to deal with. Particularly if the defendant knows what its medical reports say, but you don't. But even the defendant can make an early offer when it's only seen your medical reports. Usually this is a very bad thing, because if there's a Part 36 offer that comes early, that you're likely to beat on your own evidence, but that you may well not beat on the defendant's, that's a high-risk situation. Again, you need to explain the risks and benefits to the claimant. You need them to understand what happens if you win, what happens if you lose. They need to make their own decision. Very occasionally, I have seen benevolent early offers, and my favorite case involved a famously hard-driving defendant firm of solicitors with a high-value brain damage case, which turned on, well, there was a dispute on contributory negligence, there was likely to be a dispute on the need for care, and this hard-driving defendant's firm invited us to a settlement meeting and made a very generous early offer. And even better, they said, we won't make it as a Part 36 offer. We'll give you, say, 6 months to finalize your evidence on the care claim, and then you can make a decision on this very generous offer. And we did. We went and finalized our evidence. It turned out the claimant wasn't likely to need sufficient care to justify periodical payments, which really was the question that might lead us to rejecting the offer. We accepted the offer 6 months later with no adverse consequences. That has happened to me once in my career. More often you get an offer pitched early that tends to be rather on the low side. Usually you can just reject it. You can say we're unlikely to beat this. Defendant usually follows a progressive approach and takes longer to get up to a sensible level. Sometimes though, they make a dangerous offer early on, and you then have to leave the claimant to make his or her own decision when you've valued the risks and the benefits on both sides. Random approaches. This does occasionally happen. Sometimes it's because you're suing an individual who makes bad decisions. Sometimes you get an outright change of representatives on the defendant's part. Ultimately, though, two sets of lawyers should be able to look at the same case and reach similar valuations, albeit there are difficulties where you have the two peaks. Balance of risk under Part 36. Bear in mind that it's a very bad thing for a claimant to fall under a defendant's Part 36 offer. Failing to beat your own offer is still a win. Beating your own offer is nice. The bonus is an icing on the cake. But that intrinsic fact means that you have less worry about failing to beat your own offer. If the defendant's trying to get you to move, don't be afraid to point that out. The CPR is drafted such as to make it more important for the defendant to make offers than for you. How to do settlement. Direct negotiation is ever popular. JSMs are also popular. Formal ADR is becoming more common. I see it less often in personal injury clinical negligence cases, save that PTSHs are now mandatory in some areas. Find out if you're litigating one of those areas and find someone who's got experience of them, because they tend to be quite aggressive. Judges will get hold of the case and force as best they can each party to make such admissions as are possible. If you do go into such a settlement forum, be prepared for that pressure. Make sure your client is prepared for that pressure and you've given proper advice on the risks and benefits. Persuade the moderator that you're right, if at all possible, because the more pressure they bring to bear on the other side, the better. Make sure your client can withstand pressure that comes from the moderator. A few final remarks before I move on to Andrew's talk. Costs inclusive offers, almost always bad from the claimant's perspective. Discuss them in advance. Get agreement from your client to reject them out of hand. But always be prepared to deal with your costs after settlement, particularly at a JSM or similar. Cost budgeting has been helpful in that regard. Remember that a good settlement is always better than a trial. You can control it. You can never have full control of a trial. You can never tell quite what a judge is going to pounce on and decide is the most important aspect of the case. Having said that, a bad settlement is usually worse than a trial. Always remember that your client is your boss. And this is where the Montgomery point is really important. Instead of saying, you must take this offer or you must reject this offer, explain the risks and benefits. Explain any LEI consequences of rejecting an offer when you think there are less than 51% prospects of beating it. Leave the client to make his or her own decision. In a way, it's frustrating. It's less paternalistic. There's less agency for the lawyers, but there's more agency for the client. The best thing is, if it all goes horribly wrong, you can say to the client, we warned you about those risks. We knew there were risks that might turn out to eventuate. We couldn't stop them. You made an informed decision to accept those risks. And if it's all gone horribly wrong, well, them's the breaks. So that makes it a bit easier in some respects. In fact, it's not time for questions and answers just yet. It's time for me to stop sharing my screen. And I'm going to hand over now to Andrew Sands, who's going to give you a talk on periodical payments. Andrew, take it from here, please.
Good morning, everybody. I'm going to talk today about periodical payments and why they should feature within the settlement process, why they're very important, and how they're a superior form of damages to the more traditional lump sum award. I'm going to be covering three areas. First of all, I'm going to give you a reminder of the advantages and disadvantages of both formats of award, i.e. the settlement inclusive of periodical payments and the settlement made up exclusively of a lump sum. That will underline the reasons for making sure that proper consideration of periodical payments within the settlement process is made. I'm then going to look at where are we now with periodical payments and who can have them. It's been 15 years since the statutory regime was implemented. Believe it or not, periodical payments are still not available to all claimants in higher value cases, and I'll explain why that is. And then finally, I'll discuss how someone like me, with my level of expertise in financial services, in particular working in the field of personal injury and clinical negligence, can perhaps help during the settlement process and perhaps also within the joint settlement meeting. The current slide you'll see is just simply a quick snapshot of the firm in which I'm a director. The level of work we do is 95% of our work is related to personal injury cases. We act mainly for clients. We do some defendant work, which is always interesting because it gives the other perspective. The first substantive slide is really just back to first principles, and you'll see that I'm stating the obvious really, in that damages awards are meant to be exhausted at the end of the claimant's life, which is a difficult feat to achieve, simply because we don't know how long claims are going to live. Personal injury claimants are traditionally very cautious investors, which is reflected in the relatively recent change to the discount rate, which is helpful. But we're always looking to, as financial advisors, to look at the correct risk rating for clients from the outset, which sometimes can be a little bit higher than the course approach, particularly if the award is reduced in value through causation issues or just general risk of litigation. The main purpose of investing the lump sum element of the award is to match the inflationary need of future losses. As you'll know, there are different types of inflation which have featured within the personal injury sphere of recent times. The first of those is what you might expect to pay from the increasing cost of just general household things, which is usually recorded by the retail price index or the consumer price index. But with future losses, many of which are linked to earnings loss. So for example, the most common example would be the cost of a claimant's future care. That type of inflation increases at a higher rate than earnings-based inflation. So at the outset, periodical payments were linked to the retail prices index. There was some litigation, which I'll touch on a little bit later, which resulted in the retail price index being disapplied because that would have guaranteed an increasing loss of the claimant as periodical payments move forward, simply because those payments would have been related to the wrong type of earnings. I'll just go to the next slide to give you an example. First of all, price inflation. I'm old enough to been able to buy a Mars bar in 1980, but I couldn't tell you what the cost was then or now. But you can see that Mars bar inflation per annum has been 3.9%, and apparently they're smaller. But this caused a bit of an issue in the office yesterday when my colleague said to me that actually they cost 80 pence and they are the same size as they've always been. But it does show whatever the price of a Mars bar in today's terms, it shows that price inflation, particularly in relation to that product, has been 3.9%. You're probably aware that price inflation across the board, and in fact the Bank of England likes price inflation to be about 2.5% for a healthy economy. Now, moving on to wage inflation, 1980, average weekly earnings was £5,720, and for any of you get out your calculators, that equates to 38,000 Mars bars. Weekly earnings now is £27,880, which is over 4% per annum. So the purpose of those two slides is to show that price inflation, about 2.5% per annum, is what you would like to see, or what the Chancellor would like to see, the Governor of the Bank of England. But wage inflation goes up at a higher rate. So you can imagine if a periodical payment had been linked to price inflation, that would have been going up in value about 2.5% per annum, whereas what it really needed to link to was something related to earnings to make sure that the payment went up annually at 4% per annum or thereabouts. Otherwise, the claimant's periodical payment would have been going up to a lower rate, and that would have been compounded over time. So 10 years or so into the future, the periodical payment wouldn't buy the care that the claimant needed, and that situation would only get worse. Just a quick reminder of the benefits of periodical payments. There is no investment risk. And my job, like yours, is to weigh up risk in a slightly different sort of way. You're weighing up the risks of litigation, as Duncan explained earlier. Our job is to weigh up the risk of the right type of investment, and to make sure that on the lump sum element of the award, that the claimant's needs are met throughout lifetime. Now, periodical payments are 100% secure. So if the defendant was to default, those payments would always be paid, and I'll touch on that a little bit more later. An important point: tax-free periodical payments paid, say, 100,000 a year. Imagine if that was taxable, that would be quite significant. So they are tax-free. There's no risk as in relation to life expectancy. The payments are made for the claimant's lifetime. There's no investment cost, which again can be a significant draw on, so it's a significant headwind in relation to investments and how they progress. And as I touched a few minutes ago with the material on inflation, now periodical payments, there was an accurate match with the right type of inflation, which is measured by ASHE 6115, which is a particular measure which is produced by the ONS, and we've all become more familiar with the ONS in recent months. But the ONS prepares the ASHI data, which stands for Annual Survey of Hours and Earnings, and that can be specific for different types of jobs. You can look through all the data and find an ASHI reference for each type of job. The ASHI 6115, the ONS send people out speaking to carers. They collate the data, and the periodical payment would go up in relate or down. There's 1 or 2 years where it's actually gone down, but that was more due to the unusual circumstances post the credit crunch in 2008. But since then, the periodical payments for care and case management have gone up annually. If we compare that with lump sums, you can see that there are significant disadvantages. Volatile investment markets, and we've seen that in recent months, also related to the pandemic. There's taxation to take into account, which again is a significant headwind to investment performance. Mortality risk, again, that's a very, very significant level of risk. If the claimant lives longer than expected, and the lump sum is, let's say somebody's to live to 80 and the evidence was they would live to 70, with a cautious investment, even over many years, it would be very doubtful that significant momentum would be within the investment process that would allow to cover for the extra need of those 10 years. Cost of investment, none of that with periodical payments. The discount rate, the change in that have been helpful for the lump sum management. However, the two very significant risks, which are investment risk and mortality risk, in a perfect storm with both of those risks coming to bear, you can see how lump sum awards are way more risky. In recent times, with the markets being very volatile, the types of telephone call I get with worried clients, you tend to find that those calls come from clients with exclusively a lump sum award, and those with periodical payments are far more relaxed. This is quite an interesting slide, and it just shows how what volatility looks like. This is going back to October 1995, and if you go to the very right-hand side of the slide, you can see how the markets dipped in response to lockdown and the pandemic. The FTSE 100, which is the one that's usually featured on the news in the evening, that dropped 30%. That's a huge drop. So can you imagine investing your damages award just before the drop? Typically a cautious investment wouldn't go down 30%. That might go down somewhere between 8 and 10%, but you would certainly be starting the investment process on the back foot. Whereas if you invested at the bottom of the dip, which not many people want to do because sort of sentiment doesn't particularly favour investing when times are very troubled. But you can see those two clients, one might be getting off on very much on the back foot by investing, say, in February this year, whereas the other, who would be brave enough to invest at the bottom of that slide, of that graph, so that dip, will be getting off very much on the front foot. And those two portfolios would never align, particularly even over time. And you can see that this, from 1995, it would seem that time would sort everything out in the investment process. This slide is unhelpful in the sense that it doesn't reflect the personal injury claimant, because this assumes that money is just invested and left. And of course, personal injury claimants withdraw funds from time to time to meet their needs. Interestingly, I do have a client who invested money in 1988, £500,000, and that money was left alone because the family members rallied round and helped out. One of his brothers was his deputy, and the rest of they bought their right to buy a council house in Yorkshire. Not much was spent, possibly again due to the Yorkshire circumstances, but the upshot of all of that was this money was left alone for many, many years, and was more recently was the value of the portfolio was about £2.5 million. But again, that was unusual because money wasn't drawn down. So where are we now? Periodical payments, I hope I've got the point across that periodical payments carry far less risk, in fact, no risk. And the investment process as regards the lump sum is fraught with various difficulties. So I suppose just to summarise up to now, periodical payments on that basis should be considered as part of the settlement process. How you do that as lawyers, when you raise that with your clients, obviously it is up to you. I'm sure it varies on a case-by-case basis. So the state of play at the moment, typically a periodical payment case would feature periodical payments of care and case management, linked to RT 61150, as I've already pointed out. Some claimants dislike periodical payments. And I think over to you on when you might discuss this with them, and when you might bring someone like me who can perhaps explain the benefits of periodical payments, particularly in relation to experience of how things might look if it was 100% settlement on the basis of a lump sum. I also said that financial advice isn't always sought during the settlement process. We get involved in cases often at the fairly late on, maybe when the schedule of loss is to hand, and my view would be maybe it would be helpful perhaps earlier on if you thought that was a good thing to give the clients the advice, particularly on what lump sum investment looks like post settlement, perhaps with a view to ensuring that those who dislike the idea of periodical payments, and there are plenty of them who seem wedded to a lump sum settlement for various reasons, at least then they would have had a view of what things might look like in reality. Often I'm asked to consider whether periodical payments are suitable for other heads of future loss, and the answer, of course, is yes. Anything with a recurring element to it. We can look at the ASHI data and perhaps find a suitable index to meet the ongoing need. An interesting one is often prosthetics with a recurring element to that, replacement value, ongoing medical treatment to ensure best recovery for the claimant. All of these things are recurring. I'm a little bit reticent on that type of loss for prosthetics, simply because you might be tying the claimant to today's technology. It might not be an issue if they're a bit older and they just happen to sort of think, well, I'll cope with what's available. But for somebody younger who might want to have a lump sum to spend on the next generation of technology, all of these things need to be considered. I'm just going to, the next point is that, as I raised at the beginning, that periodical payments aren't available to all claimants, and I think we need to look at why that is, because as part of the settlement process, part of that would be to exclude periodical payments early on in case they aren't available. The court can't order periodical payments unless Section 2.4 of the Damages Act has been complied with. So basically, the defendant has to be good for the money. Can they pay the periodical payment and the uplift on those payments annually for the rest of the claimant's life? Quite often, it's a simple matter of just looking at this particular statutory section. If the defendant is a government or health service body, so the Ministry of Defence or health service trusts, no problem. It's deemed as automatic. Those bodies are deemed as automatically by the statute, so the defendants are good for the money over the claimant's lifetime. If it's a road traffic insurer or an insurer generally, if those insurers are regulated by the Financial Conduct Authority, then they are deemed as good for the money. So if there was a default, the Financial Services Compensation Scheme would step in to the tune of 100%. So most defendants are good for the money, and periodical payments can be negotiated or considered as part of the settlement process. There are some difficult areas. At the outset of the periodical payment regime, the Department for Constitutional Affairs provided some guidance and saw difficulties with bodies like the Medical Defence Union and the Medical Protection Society, which they are not insured, so are not covered by Section 2.4 that we just looked at. Lloyd's cases, for various technical reasons, for cases notified prior to 2004, there were difficulties there. The interesting one I find is the limited indemnity in insurance cases. So if you've got an employer's liability or public liability case, that needs to be looked at because often the level of cover is limited. You compare that to road traffic accidents where there is no limit on the amount of cover. So, for example, if you have a case based on employer's liability and there was a £10 million limit on that indemnity, whether or not that is suitable for periodical payments needs to be looked at. From that £10 million, you would have to take out, assuming there were the settlement value on a lump sum basis was £10 million, you would have to take out the lump sum element of the claim, usually both sides' costs. So that might typically leave, say, £7.5 million that could be tested for suitability for periodical payments. And the way you would do that is to, or I would do that, and that we get asked to do that quite often, is to look at what the periodical payment might be in year one, claimant's life expectancy, say 50 years, and then you would work through how much is going to be eaten up year by year on a sort of a totting up process, bearing in mind a reasonable assumption for inflation of the periodical payment, and is there enough headroom to make sure that when you add all those numbers together, there's sufficient cover in the indemnity. And once or twice I've come across cases where the court really wouldn't want to order the periodical payment because the indemnity is insufficient. So that's something we can look at. Medical Defence Union, just going back there, they did have insurance in place until April 2013. So the cases notified before that, there is insurance. So again, a £10 million indemnity level, which would need to be tested for suitability for periodical payments. Also, we have the situation where the defendant, who is good for the, which is good for the money, the insurer is good for the money, but simply refuses to go down the route of negotiating on periodical payments. Now, that's a difficult area, and how to deal with that is over to you as lawyers in some respects. We'll touch on that again in just a moment. So I suppose we've looked at why periodical payments are a good idea and put as part of the settlement process and should be considered in appropriate cases. We've looked at who can have them and there's perhaps fairly rare cases of claimants who can't have them, sadly. So the question really is, how can someone like me help? And we prepare pre-settlement reports which cover issues such as are periodical payments available to the claimant. We look at the indemnity levels in the manner I've just described. We also look at allocation between the capital sum and periodical payments. What's appropriate? And again, this is through knowledge of what things look like post-settlement and why claimants need a lump sum award in addition to periodical payment and the financial flexibility that gives them post-settlement. And part of that process is looking at periodical payments for heads of loss other than care. And you might come up against some resistance with defendants. I know the NHS are very keen to look at periodical payments in circumstances other than care and case management. They're open to that. It suits their funding requirements. Better sort of pay something on the drip rather than to have another £1 million or so going out of the NHS budget, the trust budget for that particular year. My experience is defendant insurers take a different view. They have responsibilities to shareholders. They like to close the book. The accountants like to know what the liabilities are. Hence, you do get some resistance where defendants don't want to go down the route of periodical payments. For their bookkeeping, too many open-ended liabilities on the books is something which they don't like. So hence the reason why that they balk at the idea of periodical payments, and we end up in the settlement meeting situation where the defendant has said, no, what can we do to help you weigh up whether or not to push forward with that case, or whether or not just to think, well, there's too much risk in going to trial, as Duncan said earlier. Once it's at trial, it's out of control, and you might be exposing the case as a whole to judicial scrutiny, which might not do you any favours, or the claimant any favours. So it's a case the defendant says no. What we can do, we can prepare comparisons. We do this for claimants post-settlement. We're looking at cash flow analysis, and we can do the run cash flow analyses for settlement on the basis of a lump sum, using sensible assumptions, of course, and then the same type of analysis with a settlement which would include periodical payments. And if it turns out that the periodical payment type settlement, if that could be obtained, was far better for the claimant than the lump sum, then it will be over to you to assess the risk in whether or not you want to negotiate harder or walk away or even go to trial. That's a difficult call, I know, but we can help with giving you the information for you to look at risk from the claimant's perspective. Also, settlement meetings, consideration of the heads of future loss. I've already touched on that. So just to summarise, I think it's very important. One other point, actually, I wanted to raise. People often ask, what sort of size of case is a periodical payment case? And clearly, those sorts of cases are at the higher end of the spectrum of settlement amounts. But if you imagine, say, a claimant with 10 years life expectancy, and the defendant won't budge on a lump sum settlement. In those sorts of circumstances, I would say, well, if the claimant was to live 2 or 3 years longer than the 10 years evidence that you had, you wouldn't have sufficient time, investment-wise, to generate momentum to meet. You might get sufficient traction over those years in good investment conditions to perhaps meet 1 or 2 years of extra years, but certainly no more than that. And if that was a claimant who maybe needed 10 years worth of care at £50,000 a year, that's £500,000 plus. You can see how that might overall, that claim might, if there was no loss of earnings, they were reasonably elderly, that claim on a lump sum basis might be under £1 million. So that's one example of perhaps you want, in this day and age of eye-watering amounts due to the discount rate, which has been obviously corrected after many years of being wrong. That does seem like a case of relatively modest value, but that will be a good indication of a starting point. So I'll finish there because I know we need some time for questions.
Well, thank you very much for that, Andrew. We have had some interesting questions. We'll try and get through them all in the few minutes we have. Andrew, do you want to handle, I thought there was a question for you. No, it's a question for me. Reasonable reduction to a settlement offer for litigation risk before trial, up to 25% for litigation risk depending on prospects. So litigation risk, you can't really have a formula for it. There's always a litigation risk, but it tends to go against both parties equally. In other words, the risk that you can't assess could be against you, could be against the defendant. And it's very easy to turn to the defendant and say, well, yes, we might lose because the judge picks up on a point that we didn't think was important, but so might you. And if that risk is even, then you can always tell that to the defendant. So I wouldn't like to set out a formula as to what to deduct in respect of general litigation risk. Having said that, if it's a liability dispute, if there's a major causation dispute with two peaks very far apart, there's always going to be at least some risk involved there. So case-by-case basis, I think, is my answer for that. Andrew, do you see the question in the chat about what's in it for a defendant in settling on periodical payment terms?
What's in it for a defendant?
Yes.
Well, I don't think that matters. I think to be honest, I think, is it fair to the claimant? And I think you'll find that, you know, going back to the case law that came out of the genesis of the periodical payment statutory regime, the court's made it quite clear that the court isn't particularly interested in what's in it for the defendant. It's what's in it for the claimant, and that's why the regime came about in the first place.
Yes. Working up the questions, the next one is an interesting one about an early Part 36 offer in a catastrophic injury case where the claimant is a patient or a minor. The questioner is exactly right in saying that costs risks are reduced, because if you do have to take it out of time, a judge is going to look at the factors from CPR 3617 and ask, is it unjust to award the claimant to order the claimant to pay the defendant's costs from the last date for acceptance of the offer? And if the answer is, well, hang on, we couldn't have got approval to accept this offer until a year had passed, a judge, I think, is unlikely to make an adverse costs order. In fact, receiving an offer like that, I would even try and engage with it. I would say to the defendant, well, we're very interested in this offer, even if you think it's probably too low. We'd like to explore it, but we can't advise settlement until we do the following. We need this medical expert and that report and the following account of care needs or whatever. And say, well, look, keep that offer open, please, for 6 months. We'll go and do these things and then tell you at the end of it whether we'll accept it or not. The defendant may or may not engage with that, of course, but it's certainly worth a thought. Andrew, I think the next question coming on chat was, oh no, I think you've already addressed it, it seems. Just adding my own oar into the water there, the advantage for a defendant of periodical payments is that damages are then more likely to be right. In particular, if the claimant dies young, you don't wind up overpaying. The flip side risk of that, of course, is if the claimant dies old, then you do end up paying more. With the discount rate probably more closely matching what the true discount rate is, there's less of an advantage now to defendants in a lump sum offer. So it tends to be neutral. Just going back up there. Mediation as an option to test the veracity of an opponent's case, or indeed your own. The first thing I'd say about that is you do want to test the veracity of your own case, but in private. You don't want that to happen in any forum where the defendant can see you, because if the defendant realizes you've got problems, then the consequences will be negative. Testing the veracity of the other side's case, well, that can be a very interesting thing to do. A mediator will put pressure on the other side to settle, and you may see whether there's any weakness coming out of that. So that can indeed be a sensible option. How are we for time? We have 1 minute left. Deal or no deal analogy, but the questioner is very right to point out that you don't actually get to open the box if you settle in litigation. That is absolutely right. It can be frustrating for a client, but again, you just have to explain that. A better analogy is poker, where if you settle, if you fold or your opponents fold, you never get to find out what the other people were holding. But fewer people have played poker than have seen deal or no deal. And lastly, if the insurers pull the plug, is the claimant still liable for the premium? I have been trying to find that out in the half hour or so since I learned of the question and haven't got a clear answer. Like I say, I don't think I have ever had a client who's actually said, no, I want to continue against your advice. You would have to read the LEI policy. I have found one online and started going through it, but haven't found anything that determines the point. My suspicion is that yes, the premium is still something that's that they'll be liable for because they've had the benefit for the insurance. Costs risk of pursuing periodical payments in the face of a generous lump sum Part 36. Well, the risk, of course, is that you don't get it. The risk is that you lose, and then if the Part 36 bites, you may well end up in an adverse cost situation. So you have to ask yourself very carefully, what are my odds of winning on the PPO point? And again, then you'll need expert evidence and so on in that regard. So we have just about passed the 1 hour mark. I think we've answered all the questions. I don't propose to drag things out any further, as you've all now got your CPD. Thank you very much for your attendance, and Lisa, I will leave you to bring the session to an end.
Thank you very much.